When government gets to decide which messages are approved, we don't have a country where it's free speech. We have official speech. Imagine this in your own life. What if government set up a rule that said you were free to protest about Palestine, but not about Israel? Or you were free to protest about climate change, but not about border security? That's the evil and that's the risk of content-based speech restrictions. Free speech only survives when every idea gets a fighting chance, even the ones you hate. To be able to preserve that free marketplace of ideas, everybody's voice has to be safeguarded. And that's why the police department of the city of Chicago v. Mosley, what we're jumping into today, is vital in understanding the First Amendment, because it protects anyone who's ever protested, handled a sign, or went out on the streets to share their views. We just visited Jones High School and discussed Mr. Mosley's plight. For a moment, let's step back to examine what was happening in America at that time. Chicago, 1968. The city's a powder keg. In April, Dr. Martin Luther King Jr.'s assassination sparked riots on the West Side. And by August, the Democratic National Convention exploded into chaos. Mayor Richard J. Daley deployed 12,000 police officers, plus thousands of guardsmen, to restore law and order, and the situation spiraled out of control. Officers severely beat and gassed protesters in the streets. Around the same time, on the city's south side, a quieter drama was unfolding. Earl Mosley, a black postal worker, spent months peacefully picketing outside Jones Commercial High School. He marched alone with a handmade sign that read, "Jones High School practices black discrimination. Jones High School has a black quota." Mosley was protesting what he saw as a racist hiring and admissions policies at the school, a solitary man calling out injustice while students walked to class. But to Chicago officials on edge, even Mosley's one-man demonstration was undesirable. City officials, already panicked about protests, wanted him gone. One day after Martin Luther King's death, the city rushed through a law. It banned all picketing within 150 feet of schools during school hours, except for labor picketing. Mosley saw the new law in the newspaper. He called the police for clarification. The answer was simple: keep protesting and you'll be arrested. So Mosley sued. His case, Police Department of Chicago v. Mosley, would change free speech law forever. Imagine if your right to speak out depended on whether the government liked your cause. If you were marching for higher wages supported by Mayor Daley's Teamsters, okay. Marching for racial justice? Sorry, forbidden. This case asked, can the government silence you just because it doesn't like what you're saying? At the heart of Mosley is the First Amendment principle of content neutrality, and it's one of the most important and misunderstood ideas in free speech law. Content neutrality means the government cannot treat your speech differently because of what you're saying. Justice Thurgood Marshall got it best. Above all else, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. What does that mean for the average person? It means you don't need the government's approval for your cause. It means today you can rally for Israel, for Palestine, for environmental action, for gun rights, for life, for choice, without having to ask, is this an approved message? Because if we allow government to regulate content, eventually every unpopular or inconvenient cause is at risk. So how did Mosley wind up being important recently? Fast forward to 2015. There's a small church in Gilbert, Arizona that puts up a tiny roadside sign advertising its Sunday services. The town fined the church because the rule said political signs could be big and stay up longer, but religious signs had to be smaller and taken down more quickly. Same issue, different era. The Supreme Court struck down Gilbert's law in the case named Reed, citing Mosley, and reinforced the principle: no special treatment based on content. Whether you're a civil rights activist in 1968 or a pastor in 2015, the content of your speech cannot determine whether your voice is heard. As a constitutional litigator, let me tell you that's something governments across America are in sore need of hearing. The second principle we want to jump into, Mosley just wasn't about what you could say. It was about who got to speak at all. The city's law didn't just discriminate based on message. It discriminated based on the identity of the speaker. If you were a union Teamsters member in the Good Old Boys Club of Mayor Daley's Chicago, your protest was legitimate. If you were a citizen protesting discrimination, your protest was criminal. No principle cuts deeper into the American soul than this: the idea that the law must treat every speaker, every citizen equally. As more than a few commentators have noted, if the government can decide who gets to speak and who doesn't, then speech rights aren't rights at all. They're privileges. In Mosley, the court ruled that when the government discriminates among speakers without a compelling reason, it violates not just the First Amendment, but the Equal Protection Clause of the 14th Amendment. Freedom of speech and equality under the law aren't separate ideas. They rise and fall together. This lesson that every speaker must be treated equally became a foundational part of free speech and case law going forward. So the last principle coming out of Mosley that I deal with frequently across America: not every law that limits speech looks like censorship. Sometimes censorship wears a clever disguise. It hides behind words like public safety or orderly conduct or time, place, and manner. But make no mistake, when the government cares more about what you are saying than how you're saying it, that's censorship, plain and simple. In Mosley's case, Chicago said they were regulating protests near schools to avoid disruptions. Sounds neutral, right? Reasonable, even. But we all know the case wasn't about disruption. It was about discomfort with the underlying message. And under the First Amendment and its doctrine, discomfort is not a good enough reason to silence you. Governments absolutely can regulate the logistics of speech, time, place, manner, but those rules must be even-handed. They cannot favor certain topics, groups, or causes over others. Think about it. It's fair to require a noise permit for protests that uses bullhorns at midnight. It's not fair to require that permit only if you're protesting the mayor. So how does that rule play out today? In 2020, Washington, D.C.'s mayor renamed part of 16th Street Black Lives Matter Plaza. The city painted the words Black Lives Matter in giant yellow letters across the road, right outside the White House. It was bold. It was emotional. But it raised a constitutional question. What happens when a government allows one political message on public streets but denies others? Later, other groups requested permission to paint different messages: pro-police slogans, pro-life messages, religious expressions. They were all turned away. The same street, the same medium, different messages, different rules. This is exactly what Mosley warned about: government choosing sides in the marketplace of ideas, disguised as managing space or speech logistics. And due to some political pushback and threats of funding cuts, D.C. has finally removed its Black Lives Matter Plaza. If one message is allowed, all must be allowed, or none at all. The Constitution doesn't protect only popular government-approved ideas. It protects the right to speak, even when your message challenges the majority, especially when it challenges the majority. And this is where most people fall off the free speech wagon. Can you imagine protecting every idea? Could you permit pro-life and pro-choice protests? Could you permit pro-gun and anti-gun marches? Could you permit ads promoting COVID-19 vaccines and those begging people not to get vaxxed? Maybe I'll convince you one day that each of these messages is important, foundationally so. What's another example of the current relevance of Mosley? Today, across college campuses, the battle over Israel and Palestine isn't just a war of words, it's a war over who gets to speak at all. Let's examine how Mosley's three principles apply here. First, content neutrality. It's not a university's job to decide whose cause is noble enough to speak. Pro-Israel students have every right to rally, to mourn, to defend the Jewish state. Pro-Palestinian students have every right to protest, to criticize, to demand change. The rules must be the same for both, because if you let government pick sides today, you might find your voice silenced tomorrow. Second, equal protection. A public university cannot create two classes of speakers, one whose rallies are endorsed and protected, and another's whose gatherings are suppressed or disbanded. If Jewish students need permits and security, but others roam freely, that's not free speech, that's favoritism. And when officials start to favor one group over another, based on identity or message, the Constitution steps in to stop them. Third, time, place, and manner, real and neutral. Yes, universities can regulate when and where protests happen. They must prevent violence. They must protect public safety. But they cannot use safety as a smokescreen to block ideas they dislike. And boy, let me tell you, I deal with so many cases across America of government pretending to promote safety while it's secretly censoring people. Maybe one day I'll share those cases in another video. In the end, protecting speech means protecting it for everyone who's peaceful, not just for those we agree with, not just for those we find comfortable. As I recently penned in a petition for a writ of certiorari to the Supreme Court, this court's First Amendment jurisprudence wisely recognizes discomfort as the necessary companion of freedom. Pro-union, anti-union, even pro-racism, anti-racism, pro-Israel, pro-Palestine. Whoever you are, whatever you believe, the First Amendment shield must cover everything or it protects no one. That was Earl Mosley's stand in 1968. It must be our firm stand today. When freedom of speech becomes a privilege instead of a right, justice is no longer a guarantee, it's a favor. And there's no way to sustain a free society with favors. It's been my pleasure journeying with you through City of Chicago Police Department via Mosley. My goal is to equip you with the tools to descramble constitutional puzzles by doing deep dives into some of the most important constitutional cases around. Join me next time as we explore yet another constitutional controversy, and be sure to like and subscribe.